and welcome back. In this section, I'm going to talk about powers of attorney. It is a legal document in which you are giving the right to somebody else to act on your behalf. Now, there are two types of powers of attorney: a special power of attorney and a general power of attorney. Now, on a general power of attorney, you're giving the attorney in fact all the rights, duties, responsibilities to act on your behalf for everything. In a special power of attorney, you're going to be giving them only certain rights and responsibilities, and those are stated in the power of attorney itself. Both of the documents will incorporate this certain clause, giving and granting unto said attorney in fact full power and authority to do, perform all and every act. And this is the clause that we need to watch out for. Here are some of the following guidelines that I, as an escrow officer, would like to see in the use of a power of attorney. First of all, limit the circumstances in which you are going to use the power of attorney. If it is a matter of distance, well, that is a consideration. Secondly, your power of attorney should not be given to your real estate agent, of course not to the escrow officer, or anybody who is related to this transaction. Lenders, title companies, and we prefer that you use a special power of attorney because it does limit the responsibilities and the rights to sign to certain acts pertaining to certain transactions. We prefer that you give it to us at the beginning of the transaction so that we can have it underwritten and reviewed and approved. In order for this to be used in a real estate transaction, there are certain verbiages that should be on this power of attorney form. For instance, sell, remise, release, convey in trust, and hypothecate. Any power of attorney that is over 2 years old may not be used by the title company. A power of attorney cannot be given by a trustee of a trust, a manager of an LLC, or a corporate officer of a corporation. The power of attorney cannot be used if the appointer has passed away. The attorney, in fact, cannot sign any paperwork that gives himself the interest. For instance, I can sign the deed out to a third party, but I cannot sign it back to myself. So the original power of attorney has to be given to escrow for them to review and for the title company to review early on in the transaction. The abuse of the use of powers of attorney creates tremendous underwriting issues with a title company and with the lenders. And if you do have to give a power of attorney away to somebody else, please remember to bring back the responsibilities to yourself. Revoke that power of attorney once the transaction is completed. Thank you. I am Juliana too, and I hope that this has been of interest to you.